complainants of adult sexual assault. The reason I'm looking at adult complainants is there's so much research and so much work looking at child complainants of sexual assault, and I think it's really commonly acknowledged within the criminal justice sector and within industry, the problems with children and how difficult it is actually to get information from them, and the difficulties that might occur with children recalling information from memory, and the problems with the reliability of memory and so forth. And there's been a big focus on that, but there's been less of a focus on adults. And I think the reality is that many of the problems that apply to children also apply to adults. And when you're dealing with adult sexual assault complainants, it's not just that they apply to adults, but these adults are often very vulnerable for other reasons. Often they've been victimised in the past, often they have other mental health issues and other things that are happening in their lives, and they're vulnerable because of the trauma that they've experienced as a result of what's happened to them. So I think it's really an area that sort of we need to spend more time looking into. I mean, I think that research with children started in the 80s, and it's just been a massive flourish of 30 years of research. You know, we know a lot of what we need to know already, but with adults there's just really been very little. And when I say quality, that's a really, what is quality, what's quality evidence? I'm going to focus today more on things around the accuracy and the sort of completeness of adult complainant testimony. There's a whole lot of stuff that looks about the credibility of sexual assault complainants that also plays and feeds into this. But I'm going to touch on that less today because I'm going to focus more on this issue here, this less contentious issue and perhaps more obvious issues. So why do we care? Why do we care about sexual assault? Kathy Daly, who's actually from my university, did a great study that sort of basically looked at attrition in sexual assault cases across 5 countries. These countries were, Australia was included, England and Wales, Scotland, Canada, the United States of America, I think I've got them all there. And she basically compared, well, how, what happens to these cases? Well, what she found basically from looking at the self-victimisation surveys that have been done over time, she looked at all the work that's sort of been done in attrition in the last 30 years basically. And what she found is that from self-report surveys, it seems to be the case that only 15% of people who sort of identify as have been victims of sexual assault actually report to police. So that's a really, really small number. You'd think. It's hard to compare this to other types of crime because we just don't have as good data on it. But also what she did is she then tracked those cases through, and she looked at cases, well, what happens when they report to police? What's the drop-off and what happens there? And what she found is when she looked at these, the cases of all the sort of attrition studies, about on average only 30% proceed to prosecution. So that's 30% of cases that report to police. So that's 30% of the 14%. So that seems relatively low. And there's a variety of reasons for that, and we're not going to go too much into those today. But in the next stat that she came up with was that only 12.5% of those reported to police result in any conviction for a sexual offence. And only 6.5 result in a conviction for any of the offence charged. So that's pretty low numbers. It's sort of like 1 in 100 people who are sexually assaulted actually results in some conviction. But part of the difficulties that arise with it is because, as I was saying before, people have stereotypes or ideas about what a typical rape is. And the reality is that most rapes don't represent that at all. Right? In most rapes, the offender is known, as an acquaintance or a family member is known to the victim. But these preconceived ideas about what rape is seems to result in fact finders or people placing blame on the complainant for what happened. All right? So she went up, she went up to the bedroom, up to his apartment with him, so she must have consented. She chose to do that, so at that point consent was given because everyone knows that if you go back up to the apartment that he expects sex, or he bought her a drink and she accepted that. That means, and so there's really big issues that are emerging around that, which is really interesting, and I think a lot of the work that Barbara and their team are doing at the University of Queensland looks at the effect of those stereotypes, and possibly what we can do about that in terms of letting jurors make more informed decisions, or perhaps how to put those stereotypes to one side when they are decision making is a really big and important area of research. But for today, what I'm going to focus more on, it's just a sort of broad context, but what I want to focus on is more the system variables, or this coin was sort of termed by Gary Wells in 1979, the idea that there are some things that are in control of the justice system that we can do something about. If an offender comes in and some random person in an aggravated robbery points a gun at someone and runs off, the amount of time the witness observed the offender for is not something the criminal justice can do anything about. That's just a fact. They've either had enough time to sort of encode a good memory of what the person looks like, or they haven't, into their memory. Right? However, when we then show that witness a line-up later with either 8 people or 4 people in it, or just show them one picture to try and identify who the person is, that is something the criminal justice system has control over. Right? So what they do in response to that. So I just want to sort of apply that approach to it today. So I'm going to really, really focus on the things that the criminal justice system does have control over and can do things about now to improve the quality in terms of eyewitness testimony. So the first thing that I think that I wanted to, I'm going to go through 5 different things that we know, I suppose, from the science. And the first thing is that memory is fallible. We know from a whole stack of science done by cognitive psychologists that adult memories have problems, right? Memory is constructive, so it's not like a video recording. So often when you replay something that's happened in your life and experience, often you see it in pictures and you get this feeling like that it was like a video recording, but it's not. We know, and it's pretty clear from the research, that memory is a constructive and a reconstructive process. Right? So we're not replaying the exact event in our mind. What happens is we're replaying snapshots, it seems, of our interpretation of what happened, and we're supplementing that with other information, like with the networks in our, I suppose, the schema or the frameworks in our brain that help us analyse and process large amounts of information based on our previous experiences and based on other things. And so because memory is fallible, it means that how memory is elicited can make a really big difference to the quality of the information that is elicited. And I think that what's really important about this is that when you think about how police interview witnesses, how whoever, and I should say that, I'm talking mainly about police, but obviously I'd like you to think about how this might apply to your profession. If you were busy interviewing people about a real life event, exactly the same things will apply. But it's really interesting from a policing perspective, because from a policing perspective you think about, well, about the care that is taken to preserve a crime scene, right? So when a crime scene, when there's a crime, a serious crime occurs, a great deal of care is taken to preserve that evidence and present it for contamination. So police will wear their little plastic suits, wear their little masks. They're not spreading the DNA. You know, they'll put down your stepping plates, so that you walk. So when you're walking through that scene, you're not contaminating that scene with anything that's from you. Right? And you know, and you obviously they preserve the scene as soon as possible, and they do that examination and they are aware that over time the scene will deteriorate, so they've got to get to it as quickly as possible to prevent it from deteriorating. You know, and you think about when you think about that, and you think about the amount of effort and care that's taken with that, and then you think about, well, how much evidence or information is gathered by police from a scene compared to from witnesses, and certainly in sexual assault complainant cases, where the main source of evidence is the complainant, how much information is gathered from them, and what care is taken to ensure that when police are gathering that information or examining, I suppose, that memory crime scene of that complainant, that they're examining that in a forensically safe way, so they're not leaving any of their traces on that scene, that they're preserving that initial account, which will, like memory does, deteriorate over time. And I think it's just a really nice sort of, I suppose, analogy when you're thinking about eyewitness memory and the problems with it, to think about that. And I suppose the theme through what I'm going to talk about today is about, well, how we can apply those more sort of forensic ideas around how we examine information that comes from a adult rape complainant's memory, and how we can preserve it in the most pristine way. Expectancies can also influence how an event is remembered. So if there's something that they expect to happen, or your stereotypes might affect. And a classic example here of that is there's a video that we use to help train police officers. One of the officers watches the video as a witness. And in the video, we deliberately have a male and a female who sort of point this gun and fire a shot, but it's really difficult to work out that it is a female. She looks quite neutral, quite gender neutral. And you can if you know, and once you spend enough time looking at it. But what's interesting, every time we interview them, just about inevitably they both say there's 2 males that are at the door, because stereotypically, that's what they expect, yeah. I mean, it's just an anecdote, but there's research to back this up. I'm sort of giving you anecdotes to illustrate what the research says, and it's strong research. This is like 20, 30 years of research that's showing this. Another study is a classic study that sort of looks more about the use of questioning, or how people draw inferences in memory. And this is sort of one of the founding studies. Elizabeth Loftus was one of sort of the founding researchers around eyewitness testimony. Anyway, she did the study basically where she showed a room full of people, a film of 2 cars in a motor vehicle accident. So there's 2 cars collided with each other. Everyone saw the same film, but what she did is she then broke up that big group into smaller groups, and she asked all the smaller groups a series of questions, and one of the questions was the most important question that she was interested in, but what she did is in that question, just changed the verb in the word of that question, all right? And I'm giving you just 2 examples. There were other questions, other verb changes that she used. But what she did is she asked one group how fast were the cars going when they hit each other, so the verb being hit, all right? And in another group, she asked about how fast were the cars travelling when they smashed into each other. So hit versus smash. So smash is obviously a far more expressive verb, and that's exactly what she found. What she found is that the estimates of speed increased with the word smashed, were higher in the smashed group than they were in the hit group, to a statistically significant level. Now, that's pretty scary when you think about it, but what she did is she took it another step further, and what she did is she brought all the same participants back a week later. And what she did is she then asked all the participants, well, you watched that film. I want you to tell me, was there any broken glass at the scene of that crash? Now, there wasn't any broken glass, all right, because at the scene. But what she found was that the people in the smashed group were far more likely to falsely report that there was broken glass there than those in the hit group. Right? So not only did the use of these questions change the witnesses' immediate response to what happened, but it also changed their later memory for what went on, which I suppose just goes to show how subtle things can impact an eyewitness account further down the track. So anyway, so we've got all these problems with memory. So I think basically I'm going to identify each problem and then talk about what the solutions are. I mean, the solutions are is that when in the criminal justice system, we need to be aware of this. Whether we're investigators or lawyers or judges, dealing with individual cases, or whether policy makers making policy around how witnesses are interviewed or around instructions given to a jury or whatever, we need to be able to take this into account, the very issue that eyewitness memory is fallible and that will affect witness accounts, and that's just an inevitability. All right, the second thing that is really important is that how a complainant is interviewed can influence the reliability and completeness of his or her account. And this, I suppose, in some ways regards moving on from the Loftus research that I described to you before, which looked at the more sort of suggestive questioning. What we know about how interviewing can have an effect is what we know is this, is that when witnesses are asked open questions, they tend to give the most accurate responses. So these are questions like, tell me what happened next. So these are questions that don't imply what the answer will be, and then encourage the witness to give elaborate detail. So in these types of questions, the witness is basically, you're just saying to the witness, just go, tell me whatever you can remember from memory and tell me. I'm not going to put any boundaries around that, you just tell me what you know. And we know that those are the most accurate. What is the accuracy level? Well, who knows, really? But those are the questions we can most rely on. What we know also, and I'll start down the bottom here, is that leading questions are the least helpful kinds of questions, right? Leading or suggestive questions can negatively influence the answer. So like, for example, in that Loftus study, you could say it was sort of leading. Asking smashed rather than hit was sort of implying some sort of speed, but things like he touched you, didn't he? Tell me, and questions that imply the answer are a problem for memory, because what happens is that how the question is asked can influence the type of information that's recalled or influence the person's memory for what went on. And we know that these questions are problematic, and there are rules of evidence around that and forbidding those sorts of questions in the courtroom from in evidence in chief anyway. So when the witnesses, the prosecutor elicits evidence from the complainant. And we know people are particularly careful about those with child witnesses, but the reality is adults are also vulnerable to those. Now, in the middle ground here, we've got specific questions, all right? And these are the questions people tend to ask in everyday dialogue, and that investigators tend to ask as well, which is, what was he wearing? Where did he touch you? So they're asking for a specific piece of information. Now, the thing about these specific questions is they can help elicit more information. So there's a tendency to use them. So if the witness doesn't mention, or the complainant doesn't mention what he's wearing, by asking the question, what was he wearing, the complainant might search their memory and search for that sort of information and come up with it, and that might be quite helpful. But the problem is, because of the social dynamics in the interview, the complainant may be tempted to answer that question even though they don't know the answer. You know, as a basic social human interaction, if I ask you a question, I don't normally ask you the question to trip you up. I ask you the question because I think that you probably could have an idea of the answer. So what can happen with these sorts of questions is that a complainant can give an answer even though they don't have one. So for example, the question, what was he wearing? Or what were you wearing? A complainant might rely on their stereotypes or their ideas of what he might be wearing. Oh, he was wearing dark clothing, or he was wearing jeans because everyone wears jeans. Or, you know, the question, what colour were his eyes? Well, his eyes were blue because I know his hair was blonde. All right, making these assumptions based on these questions. And so these specific questions can create problems. And so the accuracy of the information can decrease slightly with those types of questions as well. So that's important to be aware of. Now, I just want to differentiate a little bit more about these different types of leading questions, because the problem is that sometimes leading questions can look like open-ended questions, all right? Or some people would say, well, open-ended questions phrased in a leading way. And it's important to be aware of this, because this is, I think, an easy mistake that investigators make all the time. So the first question here, Eric had an AJ's logo on his van, didn't he? This is from an actual study that Steph Sharman and Martine Powell did. In this question, the witness has not mentioned AJ's logo on the van. In fact, there was none, right? And I think we can all agree that it's quite a leading question. If you all looked at that, you'd say, oh, that's a leading question. There's no problems there. We know that's inappropriate. We won't use that sort of question, right? You also notice it's a very common type of question in cross-examination. But anyway, that's a different matter. Anyway, so that's quite obviously a leading question. This, on the other hand, when the witness hasn't mentioned AJ's logo, all right, and the officer or the interviewer says, tell me about the AJ's logo on Eric's van, that's also a leading question, because the interviewer is implying that AJ's logo is on the van, all right? And so I suppose I'm including this in here just to demonstrate it's not actually really as simple as it might look. It's actually quite complex, the types of questions that you can use and how they elicit different types of information. In fact, academics are continuously arguing about this as well in the different categories. But the problem is what the research suggests, or the few studies that have been done on this, is this one here, this question here, is actually more likely to create a decrease in accuracy in someone's recall for what's gone on, and for someone to later misremember about AJ's van. All right. And we don't know exactly why that is. It might be because when they're trying to think of that answer, they're really actively thinking in memory, and that it causes them the memory to work harder on AJ's logo, and therefore results in a stronger memory for that, and they're more likely to say it. So witnesses are more resistant to this type of question than they are this type of question. Right? It's not so obviously leading. So different types of questions, how the questions are asked really matter. Another thing that really matters is how witnesses are interviewed. And cognitive psychologists have done a lot of work on this as well. So not just the questions that are asked, but but the other dynamics that go on in an interview. So Fisher and Geiselman are big founding leaders, I suppose, in how adult witnesses are interviewed. They first did studies in the sort of 1980s looking at what they call the cognitive interview. And what Fisher and Geiselman are, they're cognitive psychologists who were one day approached by a couple of members from a burglary squad in police members from a burglary squad in Florida, and these police members said, we feel like we can get more out of our eyewitnesses to these robberies, but we just don't know how. You guys, cognitive psychologists, can you spend a bit of time away from playing with your pigeons and come and help us, you know, and apply what you know about science and about how memory works to try and get more information and more detail. Oh, yeah, sorry. yeah, you're probably right. It's more stereotypes, they're so problematic. And that's exactly what they did, and they founded what's called the cognitive interview. And basically what they did is they took what they knew about how memory works and they used that to try and enhance the amount of information recalled. And they did this successfully. Studies have since shown that with the cognitive interview, it on average it gets 40% more detail than a standard interview, right? Without compromising on accuracy. Right? So the average accuracy rate is lower. I mean, it means there's still more errors because there's more information, but the average accuracy rate is lower. And what they did things is, but what they found very quickly, and I'll talk about the mnemonics or the memory aids that they used in a little moment, but what they also found is that police were just actually really hopeless at interviewing. They just had really poor communication skills, so they layered those communication skills in. So those are things like building rapport, which is, just everyone agrees that that's fundamental. And these are standards in all interviewing protocol, not just cognitive interview. Having a clear description of the rules to the interview process, use of open questions as the primary method of eliciting information, and a willingness to explore alternative hypotheses, so having that open mind. And these are foundations not just to what Fisher and Gosman did, these are foundations to child interviewing protocol and to all other interviewing protocol. Even with suspects, the foundation is exactly the same. So they layered that in there. And with the cognitive interview, basically they used a mixture of mnemonics. So mnemonics are just memory aiding tools, essentially, that officers could use. And I won't go into each one of them in a huge amount of detail, but basically these mnemonics sort of monopolised on what they knew about memory recall. So context reinstatement is the idea that you get the victim or the witness to think back to where they were at the time of what happened, what was going on around them, what they felt and what they felt and what they saw and they heard. So to recreate the psychological and physical context of that time. And that helps with retrieving memory. So the more similar your environment of recall to the environment where the event originally happened, the better the recall. And which is something we all experience day to day. Like, for example, if you go back to your old school or your old university, suddenly you have all these memories flooding back that you never had before. And that's because you're back in the context where those memories were originally encoded. So they used that and applied it and said, okay, well, it might be tricky for officers to take your complainants or your victims back to the scene of the crime, but instead what we'll do is we'll give you a series of instructions. You can give the complainant a series of instructions to help them think back and recreate that context. And it is fairly effective at increasing the amount of information recalled. So asking the witness to think back to where they were, what was going on, what was felt, and so forth. And that's just an example of one of the mnemonics, but there are other ones that took advantage of witness memory that they used as well. And so 40% more detail. So these are things that can be, obviously, these are all evidence-based methods that can be used. So one of the things I'm working on at the moment is the problem with this protocol in an adult sexual assault scenario. So I think the cognitive interview and obviously the research has given us a really good starting point in terms of how to get the highest quality information from complainants. But I think adult sexual assault complaints cases are different. If you think about how the cognitive interview was designed, it was designed for a typical eyewitness scenario where there's a witness who experiences sort of emotionally neutral event. They're a witness to a robbery, they're not actually, they watch it from the side, they don't have the firearm pointed at them, they don't have a previous relationship with the offender. And typically these studies, of course, are tested on students as well, all right, who often have a good cognitive ability and aren't under stress so much when they're being interviewed. Anyway, and the whole sole purpose and the sole outcomes is not only are the circumstances a little bit superficial when you try and generalise them to an adult sexual assault scenario, but the other thing is the whole purpose of the cognitive interview is to increase the amount of detail. And part of the problem with that is that we're getting more and more evidence to suggest that in some circumstances detail may actually be problematic. And I'm going to talk to you a little bit more about that when we talk about cross-examination further down the track. And part of the difficulty with that is it makes sense for an investigative perspective to get more detail in an eyewitness robbery scenario because you don't know the identity of the offender. So without the identity of the offender, you have nothing. You need to identify who that person is. So you need to use every tool in the belt, every cognitive mnemonic to try and work out, get as much detail as you can about that person so you can identify who they are. We know that in most sexual assault cases, that is not the problem. The problem isn't offender identification. The problem is, was consent given? Right. And the problem with encouraging someone to record a large amount of detail is that it can be tiring. Right? So we've got a traumatised witness, who's experienced not just a 5-minute video clip, but has experienced something perhaps overnight or over days or over weeks or over years, who may be vulnerable for other reasons, trying to maintain a high level of concentration to repeatedly go over events to recall detail. And I think there are some issues about that, and I think we can do better with that, which is something that I'm looking at the moment in terms of how we can improve that. We also know from those repeated recalls that may, well, we need to look at this more as well, but that may well reduce the coherence of the account by a witness repeatedly going over things, which is what the cognitive interview does. It encourages multiple retrieval attempts. So I think we need to learn more about that and the effectiveness of that account. The lack of coherence is a problem maybe a problem further down the track as far as confusion of the witnesses going in terms of the different accounts that they give, but it also might be a problem for police in terms of them processing the information that the complainant gives and trying to work out what's relevant and what's not. So we need to do more work, and I'm doing some work at the moment with Martine Powell particularly, and I've done some work with Mark Keble and Becky Milne as well. I'm trying to work out what detail is relevant, so talking to investigators and prosecutors and asking them, well, what do you think is really important in terms of establishing consent, or what's investigatively important? And then to try and look at ways that we can perhaps elicit that information in a less onerous way on the complainant. It's really hard to test this stuff in the lab, so it's one of those things that we think we're going to have to. I think there's really strong research and theory around how we can do this better, so it's one of those things we're probably going to have to just go out there and field test, because you just can't simulate those conditions, fortunately or unfortunately, I'm not sure. Anyway, and also the other things that we don't know is we don't know all the research on interviewing processes looks at how to improve recall. It doesn't deal with the other dynamics that are going on in the interview. So I've talked a little bit about the investigative and evidential dynamics and the goals around that. But it doesn't also look at the issues around behaviours. So for the clinicians here, you'll probably all be aware that when you're interviewing someone who's traumatised, you know, there's behaviours and emotions that are really difficult to manage that come with that. And we don't really know, I suppose from some of the research we can sort of anticipate what they might be, but we don't really know enough about what they are. We're doing some work at the moment asking police officers what they think are the challenges when they're dealing with these complainants. But there's things that are there, like getting a high level of detail about the actual sexual acts, about dealing with the complainant trying to manage their credibility, so only giving part of the account. In other words, not wanting to disclose that they kissed the offender earlier in the night because they are worried about the implications of that. You know, and just plain distress, just breaking down and crying and not wanting to talk about it, when of course the officer needs that information. So these are sort of areas of research that I think we need to do more on. I'm trying to actively work on, and if there's other people that want to work on that too, that's great, because we need to find out more. I think we really need to tailor what we're doing to these special type of cases. But regardless of that, and regardless of where we need to go, I think we've got a really good foundation. We know about the really important use of open questions and how that can make such a big difference to the quality of the information that's produced. We know about different mnemonics we can use if more information is required and more detail is required. And these are fundamental. So it's fundamental for police and for other people interviewing to be aware of these issues and to use, you know, the science behind that to base how they question and how they interview these types of complainants. Yeah, and that's not necessarily being done. You know, how we interview adults is often just totally disregarded. With children, it's looked at, it's scrutinised, but with adults, it's just like, just go out and interview them. Come back with an end result. Let's not go into detail about how you actually do that. And the next thing that I think feeds really closely into that is interviewing is a complex skill that is difficult to learn. So it's all very nice me telling you you should be doing all these things and this is the protocol, but it's actually really hard to learn them. And it's not as simple as it sounds. You know, in fact, a lot of the behaviours in the interview, so for example, asking open questions is counterintuitive in many respects. I mean, we don't do that every day. We ask closed questions. You know, if I asked you to tell me everything that happened yesterday and you started, well, I got up at 7:52 in the morning and I was feeling a bit tired, and then I noticed that it was a sunny day outside, and you know, or I asked you to describe how, you know, what happened when you mowed the lawns. Oh yeah, well I noticed the grass was this big and I thought I'll get the lawnmower out and I'll do this. You know, it's just, we don't naturally ask open questions, and we don't necessarily expect elaborate responses, right? Humans are sort of trained and conditioned to give short responses and to ask questions that only give short answers. And in an investigative context, it's different. You do need more information and you do need detail about certain aspects. But what's fortunate is that there is a whole wealth of information on human learning, and for those of you that are involved in teaching are probably aware of, hopefully aware of this, about how we can learn skills. Interviewing is a complex skill. Right? So it's just like playing the piano. You don't give someone a 2-hour or a week session learning to play the piano and then expect them to be some grand pianist at the end of it, or be able to, you know, and that's a piano that just sort of sits there, whereas of course a witness or a complainant has all these other things going on, and they're dynamic and there's different situational factors going on for them. Anyway, we know from human learning basically that key to learning interview skills involves understanding the principles that underpin the protocol. So they need to understand why would you use open questions, and why would you refrain from using suggestive questions? And why might be able to use it so they understand the philosophy and principles underpinning what's going on. And that they need incremental skill development, all right, that's tailored to the interviewer's individual learning needs. So that means that you don't just suddenly learn, you learn the sub-skills before you learn the skills before you learn the skills. So you learn the different types of open questions, and what scenario, be able to identify those types of open questions, know in what scenarios you would apply those open questions before you actively practice using open questions. And that practice needs to be also, when they're practicing and learning skills, there needs to be practice and it needs to be accompanied by expert feedback. And that means that someone that knows what they're doing and know the science behind it can actually give you feedback about the specific things that you're doing wrong and how to correct them, give you strategies for correcting them. All too often feedback comes from people that actually don't know what they're doing. And there's just a stack of studies and meta-analyses showing that that actually is counterproductive to learning the skill. Your actually skill level drops. And these schemes also need ongoing evaluation. And sorry, I'm saying this and I probably should have made this clear a little bit better. Evaluation studies from around the world continuously show that police interviewing practices with adult witnesses and actually with child witnesses as well just do not fit with evidence-based practice. It's very, very rare. It's been this big problem that everyone's been scratching their heads over for the last 20 or 30 years. Like, we sort of have an idea as to what a good protocol looks like, but actually getting police to do that, all right, has been a real problem. But when you look at these basic learning principles, and you look at what a typical police training regime is, you very quickly see that there's a huge discrepancy, all right? Police train are a very traditional model. Traditionally, they train in block courses, and some work I've done recently, I can't go into too much detail, but suggests that, these block courses are often 3 days to 4 weeks long, training them in those skills. So what happens is they don't have spaced practice sessions, all right, with breaks in between, and that's fundamental to learning a skill. There's no incremental approach to learning, so they're just thrown straight in the deep end. Given the most complex skills, off you go and use them, not the subcomponents of those skills building up to them. There's no follow-up after training, so they're in there practicing their skills and they're getting no feedback about how to correct problematic behaviours, or that they even have problematic behaviours, because police and others have very little insight into whether they're doing things like asking open questions. They think they are and they're actually not. And there's just no evaluation, which is typical. This is totally typical of government organisations, and I'm saying with that from having worked in New Zealand Police and having dealt with other police services. The project's done, we don't need an evaluation, we've implemented, it's all right. We're done with that, haven't we? Didn't we do that years ago? And so there's no follow-up. So, so you get studies around the world continuously saying, well, things aren't up to par, but police organisations themselves aren't realising it, that it's happening and it's affecting them because they think they've got this nice training regime, which they have dedicated time to. And, and police services in Australia and New Zealand have spent a considerable amount of time trying to make sure that it is evidence-based what they're doing, but they're just not imparting what they're doing in an evidence-based way. So, solution is use training regimes developed on principles of human learning to develop interviewing skills. And this is actually complex because what it means is that if you're getting expert advice on how to interview, what protocol you should use and what your training regime should look like, that expert needs to understand both interviewing as well as human learning principles. Or you need to have a team of experts working together to do that. And that's part of the problem, is often you might have someone with interview training, it's often someone who's an expert in interviewing that gives the training, but they have no idea about human learning principles. And then it starts to fall down. And police feel like they've got the high quality person because they've got the expertise on interviewing, but they're not getting actually imparted, learning the skills in accordance with human learning principles. The reality is with adults, the standard process for taking a statement or interviewing the record produced as a result of the interview with an adult sexual assault complainant is a statement. All right. The only place I think New Zealand has started video recording them, and so is ACT in Australia. I don't think anywhere else in Australia actually, as a matter of course, records interviews in any other way. So they take a written statement, and and there's a problem. The written statement process is whole problematic. Right. Firstly, what is the process? The process is the officer will sit down with the complainant and interview them, hopefully asking all those nice interview questions and so forth. And then as a result of that interview, they will write what the complainant said into a written account, and then they'll ask the complainant to sign that written account as true and correct. All right? That is the process. It's the process that's used predominantly throughout Australia. All right? And the problem is that written statement is not a verbatim account. And that's for all the reasons I've said before, right? The written statements are inaccurate and incomplete, and we know that from studies that compare the written statement to written statement or officer's notes to the actual video recording or audio recording of the interview. But the studies generally find 25 to 33% of information is lost in that processes, and there's inaccuracies and distortions. But police, lawyers, judges all treat that statement as a verbatim record. And that is really problematic. Now, the reason why the process is problematic, or the science that seems to be behind it, is that interviewer memory is fallible too. So what happens is the written statement process is a memory test for the interviewer. So the interviewer has to remember everything that the complainant has told them and then reproduce that in a written statement. Right? And like witnesses, you know, interviewers can't remember everything. They're prone to errors, they're prone to using stereotypes and other things. And we know, you know, common to that is confirmation bias, so that the interviewer is more likely to sort of remember things that confirms their pre-existing theories or ideas and put those in the statement and leave out things, even unbeknownst to them. They're not deliberately doing this. Leave out stuff, although sometimes they might, leave out stuff that they don't think is important.
Do subjects act when they know that they're being recorded?
Yeah, I don't know. So there's a big question. We don't know. But who knows? Yeah. But it's certainly something it's worth considering. The other problem with the written statement is there's no record of how the interviewer elicited the information. And as we talked about before, how the questions that are asked, you know, and was that information elicited from a leading question or an open question, may make a big difference to the reliability of the information that's given. All right, and these problems have led to criticisms from, you know, from lawyers, Heaton Armstrong and Walkover, a couple of English barristers, that were the first to criticise this process. You know. And there's also a lot of linguistic work about the problems with it in terms of reproducing oral language into written language and so forth. So it's just a really problematic process that is commonplace at the moment. And means that police investigators and lawyers are acting off less reliable information than they could be. So the simple solution is video record these interviews, or at least audio record them, so you have an accurate recording of the questions that are asked and the answers that are given. And then obviously in the video recording you're also capturing non-verbal communication, which may or may not be helpful. That's for this credibility researchers, but there are certainly reports from police and lawyers that they believe the complainant is far more emotional during the police interview near the time of the offence than at trial, and we know that jurors rely a lot on that when making credibility judgments. So there might be something in that, but we need to look into that more. And the final thing that I just wanted to talk about was the problem with live evidence giving processes. So this is the process by which months and usually years in our system later, years after the police interview, the complainant will go to court and give evidence in the stand and have to recall what happened those months or years prior in the event. And we know that this is a problematic process, and we know, firstly, from really basic science around forgetting, that this is a problematic process, that over time forgetting happens. So from the time of the complete, you know, obviously there's the event that happens here and the police interview takes place wherever it does take place after that, that over time memory will deteriorate. So the person will be able to remember less information and less detail by the time of the trial, or by the since the police interview, so there'll be more detail in the police interview than at trial. And also over that time there's an opportunity for memories to distort as well. There's more exposure to potential cross-contamination from other sources. So there's a number of problems with courtroom evidence that come out from that. The science was really clear from a memory perspective that you'd expect the detail to decrease. With Mark Keble and Becky Milne, we did a study where we compared police video interviews of adult sexual assault complainants. We compared that to their live evidence in chief, so the evidence they gave the prosecutor. It was only 10 cases. They were all cases that were heard in 1 year, so it's unfortunately a small sample size. But what we found basically was that more than half of the evidentially relevant information was lost. And so we were just looking at ingredients to the offence. So discussions around consent and actions around consent and the actual physical sexual acts. And most of it just never made it to trial. So it suggests that there is a substantial loss of information So supports the idea that there's a substantial loss of information of time as well. The questioning was different as well in those interviews. Complainants gave far longer responses to questions in police interviews to the lawyers' interviews, which could have also contributed to those differences, as well as the effects of memory. And the other problems with these, with current live evidence processes, is you don't know what happened in the original police interview, which is probably your most reliable record because it's nearest the time, and if it's transparently recorded about what went on. And so you can't work out where that information first come from. And I just wanted to finish off, I suppose, with talking about the problems with prior inconsistent statements. So I'm going to talk about the prior inconsistent statement in two contexts. One context is if police write the statement down, right, and it isn't the verbatim account they pretend to be. It's a real problem because that written statement isn't verbatim, but what happens is the complainant then gives evidence in the stand about what happened, right, 2 years later or a year later or months later, whatever it is, however long it is. And then what happens is the very common strategy used by defence counsel is then to cross-examine what the complainant against what they said in the courtroom compared to the written statement. Right? And at the moment this is really problematic because we don't know how many of the discrepancies are a result of the problems with the written statement process, in other words, the inaccurate record of the complainant's account, versus the things that happen naturally to eyewitness memory over time, that it deteriorates and that there might be inconsistencies that develop, versus anything else that they're trying to look for in terms of what these inconsistencies might mean. So we don't know. So there's a real problem with the written statement process in relation to that. And because it's such we think it's a commonly used strategy, and because we know from studies, experimental studies, that jurors use consistency as a strong gauge for accuracy, it's a real problem. The other way it could be a problem is because, and you'll see in a moment, is what I'm probably obviously advocating for is that you use the police interview as the basis for the complainant's evidence rather than getting them to recall it. The problem with not doing that is, what doing that also does, it means that the complainant isn't cross-examined on different versions of the account given at different times and the minor discrepancies between those accounts. In other words, the police interview is what is also the basis for their evidence. So they're not going to be cross-examined on the discrepancies between them. And we also know from eyewitness research that we would expect inconsistencies to happen over time to a witness account. It doesn't necessarily mean they're less accurate about other aspects of the testimony. And that's what's implied through cross-examination. Because you're wrong about the colour of the wallpaper, you're wrong. She can't be relied on, or he can't be relied on, about the actual sexual offence happening, or the version can't be trusted. And that's what used. And we're also doing some work on this at the moment. Some of our work with the Royal Commission at the moment, we're actually looking at, well, what has been used to cross-examine these witnesses on in terms of prior inconsistent statements? What is the source of these inconsistencies? And what strategies are Defence Counsel adopting in terms of how they're cross-examining them So we sort of have an idea that it's going on, but we really just don't know how prevalent it is and how much it is used. But anecdotally, it just seems to be rife. Anyway, so that's another problem with the process. So obviously one way of overcoming that is to video record the interview and use that as the basis for evidence, which of course then raises all these questions about credibility and how using that video interview will affect that, which is what we need to be looking at now. And that's it. Thanks so much for your time.